We do hundreds of cases here that involve a death. We call those wrongful death cases. They're governed by the Florida statutes as far as who's a survivor, who can make a claim, and this sort of thing. They're very tragic when you lose somebody. We're sensitive to that. We want to make sure that your funeral expenses are paid and all your other expenses are paid. The people that can make a claim under the wrongful death law are the spouse, if you're married, and any children under 25 years old. The law used to be, up until the early 90s, that if you didn't have a surviving spouse and the children were over 25, then there was no one to make a claim. That still applies in medical malpractice cases. If it's a medical malpractice case and an older person dies, they don't have a spouse, their children are over 25, one of the biggest tragedies we have here is having to explain to people that the children cannot make a claim under the Florida law. If that's your situation, we encourage you to contact your legislators, the governor, and try to get that changed. In around 1990, when I was on the board of directors of the Academy of Florida Trial Lawyers, we had the law changed, but it doesn't apply to medical malpractice. It only applies to other types of cases. So if the surviving spouse and all children under 25 can make a claim for pain and suffering and loss of support, if the person who died did not have a surviving spouse, under Florida law now, all children over 25 can make a claim for pain and suffering. We were able to convince Congress that, based on accountability, that the defendant should be accountable for pain and suffering to family members in these types of situations. So we do a lot of these cases. I really enjoy talking with you about it. I'm sensitive to your losses and just encourage you to give me a call anytime.